Groups were expecting this. The Supreme Court has ended constitutional protections for abortion that had been in place for nearly 50 years. It's a decision by its conservative majority. And today's outcome, overturning Roe v. Wade, is expected to lead to abortion bans in roughly half the states.
Our chief legal correspondent, Seema Iyer, is standing by here this morning. We want to welcome you in this afternoon. I'm Ann Wyatt Little alongside Casey Jones here. Now to Seema Iyer. This is a 213-page opinion. Obviously, a lot to get through here.
Yeah, Seema, so you've been combing through it. What parts stick out to you the most?
What stands out to me the most is how the opinion and the crux of the opinion, the major opinion, before we get into the concurring opinion and the dissents, it is 116 pages, and so much of it picks apart the decision-making process behind Roe and then separately Planned Parenthood versus Casey, which essentially affirmed Roe, and that was in 1992, okay? So you have to look at these decisions and say what went wrong that it didn't stand the test of time, right? Well, in Roe specifically, this court found that the state said at that point, I guess the ruling was the state cannot regulate pre-viability abortions, right? So it's really important. It's not like they said abortions are legal. They said the states, the individual states, can't regulate pre-viability abortion. So that viability term is what then came into our vernacular back in 1973. But what they defined as viability then was 28 weeks, which was later changed to 23 weeks. A big part of Roe was also defining what a trimester was. Now, I want you to go forward a little, because in Casey, they never really examined that question of viability. And this court, this decision today is saying viability wasn't explained well enough in Roe. They didn't explain what it meant, and they further didn't explain what it meant in Casey. Now, also, here, I want you to fast forward to 1992, okay? Because in this case, today's case, Dobbs v. Jackson, like the second page of the decision says we're overturning Roe and we're overturning Casey. So it's really important to learn what happened back then. Now, with Casey, Casey rejected the trimester scheme. So even though people say Casey upheld Roe, Casey rejected this whole idea of trimesters. And they said, we're going to find a new reason to allow abortions. And their reason was something called the undue burden clause. And that is, it should not be an undue burden for a woman to seek an abortion. So what's an undue burden? It is basically saying, I shouldn't have to travel 200 miles by bus to get an abortion. So that's just a little bit of what I'm trying to at least explain the density of this decision to everybody, because there is a lot of language behind it, ladies.
Well, Seema, what are some of the legal levers that can be pulled now as abortion is essentially recriminalized in some of these states and illegal?
Okay, so essentially there are 13 states with these trigger laws, and I believe Julian is going to get into that at some point. And that basically means if Roe and Casey are overturned, then immediately those 13 states follow suit, okay? So you have the 13, that's what trigger. The trigger was pulled today, and then abortion's illegal in those 13 states. All right, now moving forward to other states. For instance, North Carolina, I think Governor Cooper has already said, everything is the status quo. We're going to keep abortion legal as it has been. Again, also that viability term has always been scientifically around 23, 24 weeks right now, so we stay at that. Places like New York and California are probably also going to stay like that. But then let's look to South Carolina. South Carolina, there is a pending heartbeat bill. I believe, Ann Wyatt, you had earlier this morning read a statement or a tweet from Henry McMaster. So I believe that bill will go forward for further approval because that bill actually was kind of in legal limbo for a long time because of this Dobbs v. Jackson decision, right? But now the heartbeat bill in South Carolina, their heartbeat bill is saying that viability is at the detection of a heartbeat. Of course, the problems with that line of reasoning is that a lot of women don't know that they're pregnant until way after a heartbeat could be detected. So that's just a little snapshot of what's going to be happening in this country. And a final word is that we will see an influx of abortions in states where it's legal from neighboring states, of women having to travel in. Guys.
And Seema, if we have the time, I would love to know your thoughts on some of the ripple effects of this. You kind of touched on it earlier this morning when it comes to healthcare, economics, just the equity of all of this.
Yeah, there's an entire passage of that actually in the decision, and it's in a way it's a little disturbing because this decision relied upon that. It's basically saying, in Casey, they said it can't be an undue burden and it can't be a substantial burden. Those are the language to get an abortion, right? But this court, this opinion written by Justice Alito, is saying, well, Casey never defined that, but he goes into saying, well, who is this woman? Who's the woman that is going to have the trouble getting the abortion? And what we've seen so far in this country is that there are areas of the country where there isn't an abortion clinic or a doctor for miles or tens or hundreds of miles. And so we're going to see that. And of course, there's that economic impact, right? Because if you are in a state where you can't get an abortion, then you're going to have to travel. You're going to have to take off work. You're going to have to find someone to watch your kids. In terms of transportation, that's also a factor because some people don't have cars to go and get the abortions. And also the criminal justice system will most certainly see a surge of cases where people are being prosecuted for having an abortion. It will be a crime. So I believe that's just a small snapshot. Of course, all these abortion clinics will close. People will lose jobs. I just feel like there's so much more, and it's just really the touching point of all of this, Casey.
Seema, thank you for breaking down some of the impacts of it. We know that we will check in again with you soon.
Right now, we want to listen into House
We'll
Speaker
send it
Nancy
to the
Pelosi.
President for his signature, with gratitude to President Biden for his great leadership on this subject for the children. Mr. Chairman, Mike Thompson.
Madam Speaker, thank you very much. It's a great honor for me to be here today with these outstanding colleagues. This was a team effort. Everybody worked extremely hard for one purpose and one purpose only, and that's to save lives. Every day, 30 people are killed by someone using a gun. And if you add suicides and accidental deaths, it jumps up to 100 people every day. And then we all know how terrible these mass shootings are. It's seemingly weekly that these happen. The tragic lives that are lost to these mass shootings and these individual shootings every day. We want to do something about it. The American people want us to do something about it. And today, we're going to pass legislation that saves lives. And we don't have to apologize or suggest that it doesn't do something that we want it to do.
You're listening to lawmakers there outside the Capitol talk about another big issue before lawmakers, and that's a gun bill that they're working to get through the House there that the Senate passed last night and eventually get that to President Biden's desk.
Yes, actually, the House is planning on voting on that in just a few minutes, and we'll keep you updated on that. But we want to turn back to this landmark decision. As the federal protection of abortion access is lifted, all eyes turn to state leaders.
Abortion is already set to be almost immediately outlawed in several states. Queen City News reporter Savannah Rudisell is here with what may be next for abortion access here in the Carolinas. Savannah?
Yeah, and Wyatt and Casey, neither North nor South Carolina are trigger states, meaning no state laws change as of right now. However, state leaders say their work on revamping abortion regulations begins today. North Carolina Governor Roy Cooper tweeted, quote, "For 50 years, women have relied on their constitutional right to make their own medical decisions, but today that right has been tragically ripped away. I will continue to trust women to make their own medical decisions as we fight to keep politicians out of the doctor's exam room." Abortion providers say that they are prepared for an increase in out-of-state patients, as North Carolina may be one of the few states in the South where women still have the right to terminate a pregnancy. South Carolina Governor Henry McMaster tweets, "By the end of the day, we will file motions so that the Fetal Heartbeat Act will go into effect in South Carolina and immediately begin working with members of the General Assembly to determine the best solution for protecting the lives of unborn South Carolinians." The Fetal Heartbeat Act states that if a medical provider finds a fetus has a pulse, they cannot perform an abortion. Doctors who terminate a pregnancy after a heartbeat is detected are subject to a $10,000 fine and up to 2 years in jail. The state assembly ratified the bill, but has been unenforceable as law while Roe v. Wade was in place. Now, back to you.
All right, Savannah, thank you for that. As the day unfolds, trigger bans are being talked about, as we discussed with Seema just a few minutes ago.
Yeah, and there's a lot to unpack here, and here to help us is Julian Sador. Julian, exactly what is a trigger ban?
That's a great question, Casey. Now, these 13 states behind it all have those so-called trigger bans, meaning the overturning of Roe v. Wade today triggers that those abortion laws to take effect automatically within 30 days or by quick state action. Now, let's start with the 3 states with automatic bans. That's going to be Kentucky, Louisiana, and South Dakota. Now, all have varying penalties and exceptions. Both Kentucky and South Dakota would charge anyone who attempts or provides an abortion service with the felony. In Kentucky, it would be a 4 Class D felony. In South Dakota, it would be a Class 6 felony. However, in Louisiana, there's more penalties. In addition to a felony, providing or attempting to provide an abortion service could be punishable by up to 10 years in prison, as well as a fine between $10,000 and $100,000. Now, in Idaho, Tennessee, and Texas, the overturning of Roe v. Wade starts the 30-day clock, meaning those abortion bans will go into effect roughly a month from now. In all 3 states, providing or attempting to provide an abortion would be a felony, but in Idaho, the crime, as it's now considered, could be punishable by 2 to 5 years in prison. Also, any healthcare professional who performs or attempts to perform an abortion would have their license suspended at least 6 months for a first offense, then permanently after a second one. Meanwhile, in Texas, in addition to a felony, the person would also be subject to a civil penalty of at least $100,000 for each violation. Now, the remaining 7 states would require a process step to implement that trigger ban, whether that be the state's attorney general, governor, or other specialized official certifying the overturning of Roe v. Wade. Those states are Arkansas, Mississippi, Missouri, North Dakota, Oklahoma, Utah, and Wyoming. Now, out of those 7, 4 would have possible prison time as part of their punishments. The strictest penalty would be Wyoming, where a person could face up to 14 years in prison if convicted. Now, it's important to note all 7 of those states that I just mentioned are expected to move past that step. It's more of a formality. Meanwhile, 13 other states are certain to move quickly to ban abortions. As we've mentioned, South Carolina is one of those 13 and has already taken action. Back to you.